Good morning, and thank you for joining me on the Path to Liberty for Wednesday, June 30th, 2021. And for those of you primarily listening to the podcast edition, you may be wondering why you got the episode a little early. I'm actually pre-recording this episode a day early on the 29th instead of doing a live broadcast because I have some personal things to take care of in the morning. Anyways, with that out of the way, on this episode, we're talking about the unconstitutional war on drugs. This month was the 50th anniversary of Richard Nixon declaring basically a global war on drugs. Last month was the 50th anniversary of the Unconstitutional Controlled Substances Act going into effect. I'm going to talk about both, plus two UN treaties years earlier, decades earlier, really, that started things out before that, and a Supreme Court justice just this week was saying, at least for cannabis, it may no longer be necessary or proper under the Constitution. First of all, before getting to that, my name is Michael Bolden. We broadcast live every Monday, Wednesday, and Friday at 9:30 a.m. Pacific Time from here in my home office and studio in downtown Los Angeles for the 10th Amendment Center. Our show homepage has everything you need to follow this program, all the archives. On individual episodes, I've got a bunch of links and references for you to read and learn more on your own time. I'm just scratching the surface as I go through these topics. We've got all the different platforms we're on, all the video platforms, the audio-only podcast edition. We're all over the place. If you want another one, make sure to let me know either in the comments or email me at team@10thamendmentcenter.com, and I will certainly look into it over time. And you can also find our membership program where you can put your financial faith behind our work for as little as $2 a month, and we make it go a long, long way in support of the Constitution and liberty. Again, that show homepage is 10thamendmentcenter.com/path to liberty. Again, 10thamendmentcenter.com/path to liberty. And I couldn't be more grateful for you spending some of your time with me today. Thank you so much for being here, whether this is your first episode or you've been here for every single one since day one. I can't thank you enough. But let's get right to it. And I want to point out that a couple of weeks ago, we had a pretty sad anniversary. Here's Richard Nixon on June 17th, 1971. Let me pull it up on the screen so you can read along. There's his ugly mug. Anyways, America's public enemy number one. He put this statement out. America's public enemy number one in the United States is drug abuse. In order to fight and defeat this enemy, it is necessary to wage a new all-out offensive. I have asked the Congress to provide the legislative authority and the funds to fuel this kind of an offensive. This will be a worldwide offensive, dealing with the problems of sources of supply, as well as Americans who may be stationed abroad, wherever they are in the world. A global war on drugs was announced by Richard Nixon on June 17th, 1971. Since then, they've spent over $1 trillion. I think the statistic that I saw was as of around 2016 or so, they had spent already $1 trillion on this. And they're really, really ripping us off and destroying our liberty. Of course, I covered this, how the war on drugs has done damage to the Constitution. The way I put it in the episode of July 15th, 2020, the Constitution on the War on Drugs is like this. Few programs have done such consistent and sweeping damage to the original legal meaning of the Constitution as the so-called war on drugs. We think of it primarily as a domestic thing, but it really is a global, and it has been the source of so much really bad and unconstitutional foreign policy as well. Anyways, while we think of 1971, I know a lot of people have been talking about this in the last few weeks. 1971 is the start of the beginning of the worldwide war on drugs. We really have to go back in time a bit, decades actually, all the way to 1931, and probably before then as well. But 1931 is where I'm going to start today. We've got the Convention for Limiting the Manufacture and Regulating the Distribution of Narcotic Drugs. This was, according to Wikipedia, a drug control treaty promulgated in Geneva on July 13th, 1931, that entered into force on July 9th, 1933. I guess that was still League of Nations, not really even UN. And here you can actually see it from the Library of Congress. They have the original document here that they've got uploaded. I'll share it in the links in the show notes as the PDF so you can download it. And a few of the people I thought it kind of stuck out. The first person on this is the president of the German Reich. In the early 1930s, I had to look up to see if that was Hitler or not. It was still Hindenburg. But here we are, still laboring under a global program that had the support of the president of the Reich. We also had the emperor of Japan as well. Basically, it didn't address every drug we can think of today, but it was primarily things like morphine, cocaine, opioids. It really hasn't worked too well, clearly. This was updated and probably, you could say it was basically replaced in the United Nations in 1961 by the Single Convention on Narcotic Drugs. They basically took a bunch of different treaties over the years, going all the way back, I guess, to League of Nations. Maybe that was UN. I'm not sure even. But they went back to that other previous global treaty from the 30s and a number of others, and they created a single convention, one single treaty. And here's how Wiki put it. It's an international treaty to prohibit production and supply of specific nominally narcotic drugs and drugs with similar effects, except under license for specific purposes, such as medical treatment and research, which means almost a total ban around the globe. Earlier treaties, it continues, had only controlled opium, coca, and derivatives such as morphine, heroin, and cocaine. The Single Convention, adopted in 1961, consolidated those treaties and broadened their scope to include cannabis and drugs whose effects are similar to those of the drugs specified. The effective date of that was in 1975. So this was a global treaty in 1961 that all these signatories, we have probably, I'm not actually sure all the signatories, but it was a lot. It was 100 and some odd different countries that signed on to this. And it had an effective date of 1975. So how did they implement that in the United States? The United States was kind of the lead country on this, really pushing implementation. If the U.S. implements it, then a lot of other countries are going to as well. And here, the Controlled Substances Act, which was actually of 1970, I think it was signed into law in October of 1970, and it went into effect on May 1st, 1971. So we just hit the 50-year anniversary of this as well. It's a statute establishing, again from Wiki, establishing federal U.S. drug policy under which the manufacture, importation, possession, use, and distribution of certain substances is regulated. They always say it's just regulated, but to them, to make regular or to regulate means to control, dominate, ban, prohibit, throw people in prison, and all kinds of other nasty stuff. It was signed into law by President Richard Nixon, and the act also served as the national implementing legislation for the Single Convention on Narcotic Drugs. So the drug war in the U.S., at least on a federal level, is really a United Nations, a global program that the USA, the Constitutional Republic, the formerly federal government of the United States, now central national government, is implementing for the entire globe. It went into effect again May 1st of 1971. And here on Monday, fascinating enough, Clarence Thomas, this is from NBC News, they say one of the Supreme Court's most conservative justices said Monday that because of the hodgepodge of federal policies, at least on cannabis, federal laws against its use or cultivation may no longer make sense. Now, they don't take it really in the lead. You'd think you'd really hammer this home. I would have written this as saying Clarence Thomas is suggesting that it's no longer constitutional and has always taken that position. I'm not sure if that's a really good summary, but that's basically what he's saying. And here, a quote, "A prohibition on interstate use or cultivation of marijuana may no longer be necessary or proper to support the federal government's piecemeal approach." That was just on Monday. And this was a five-page statement that he put out just on Monday. And here's a few more pieces that I think are interesting. 16 years ago, Thomas wrote, "This court held that Congress's power to regulate interstate commerce authorized it to prohibit the local cultivation and use of marijuana." He's citing Gonzalez versus Raich, which he had a strong dissenting opinion in. I'm going to get to a couple of highlights to that in a moment. But basically, the federal government took the position that if you grew 6 plants in your own backyard, consumed them in your home, never bought or sold them, never took them across state lines, this was interstate commerce as expanded by the Necessary and Proper Clause. And Thomas gets into that as well. The reason, he wrote, the court explained, was that Congress had enacted comprehensive legislation to regulate the interstate market in a fungible commodity, and that exemptions for local use could undermine this comprehensive regime. So he's talking about the Controlled Substances Act. So the Controlled Substances Act of 1970, the implementation of a UN treaty, a global prohibition from 1961, an expansion from another global treaty signed by Hindenburg, for example, and the Emperor of Japan in 1931. This was to ban the interstate commerce of cannabis, among other things. And because of that, the court took the position that they could also ban intrastate, non-commercial activity in this plant. And going further, Thomas writes, prohibiting any intrastate use was thus, according to the court, necessary and proper, he put in quotes, to avoid a gaping hole in Congress's closed regulatory system. This does not sound very constitutional to me at all. Anyways, he's citing Gonzalez versus Raich, and he had a really powerful dissent in that case. And here's a few pieces. You can get this over on Wiki. Of course, I will link to it in the show notes. You can find the original documents from the Supreme Court as well. And he puts it this way. Respondents Diane Monson, who was Angel Raich's, and this is my ad, Angel Raich was a woman she was a cancer patient here in California, who her doctor recommended for her to be able to deal with her cancer. She was expected to die from a brain tumor. And the doctor said, you know what, use cannabis. And maybe it helped her actually get some food in her system. Of course, the munchies are real during her treatments. Maybe we don't even know because, of course, they've not done the proper research because it's been prohibited from happening. The federal government doesn't want this to happen. The police state hates freedom. And, of course, Big Pharma and the pharmaceutical industrial complex certainly doesn't like this as well. And then the military doesn't like freedom of choice and people being able to make their own medical decisions as well, especially when they're waging multi-decade wars in places like Afghanistan, in Colombia and elsewhere to enforce a global ban on certain substances. So you've got all the establishment, all the deep state is against this stuff. And Angel Raich was using this. Her caregiver, Diane Monson, I believe it was grown in her home, 6 plants in her home, and they consumed, at least Angel did, maybe both, consumed at Diane's home or at Angel's home in Northern California. And Thomas put it this way. Respondents Diane Monson and Angel Raich use marijuana that has never been bought or sold, that has never crossed state lines, and that has no demonstrable effect on the national market for marijuana. And I would even say that he was crossing the line there, because he's taking the New Deal position, which I'm going to cover a little bit later briefly, that interstate commerce, according to the founders, did not mean just stuff that might affect commerce in other parts of the country. It was literally commerce across state lines and the associated navigation, transportation that went with it. So even if it had a demonstrable effect on the national market, according to the founders, this would have been unconstitutional in the first place. Anyways, Thomas goes further. If Congress can regulate this action, this plant that's been grown at home, never been bought or sold, never crossed state lines, if Congress can regulate this under the Commerce Clause, he wrote, then it can regulate virtually anything, and the federal government is no longer one of limited and enumerated powers. And this is part of why I say few programs, if any, have done more damage to the original legal meaning of the Constitution than the federal war on drugs. And I think Clarence Thomas may agree with me on this. Going further, he wrote, and this is his dissent in Gonzalez versus Raich of 2005, certainly no evidence from the founding suggests that commerce, the word commerce, included the mere possession of a good or some personal activity that did not involve trade or exchange for value. So he's recognizing that the people of the several states, when they approved, they ratified, they gave legal force to the Constitution, that no one was actually accepting it on the view that commerce meant just mere possession of a good or some personal activity that did not involve trade. They meant it as interstate commerce. He goes on, he says, in the early days of the Republic, it would have been unthinkable that Congress could prohibit the local cultivation, possession, and consumption of marijuana. And I like how he put that. It would have been unthinkable. This would not have been supported. Look what they did in response to attacks, for example, in Pennsylvania in the 1790s. That's just quick inside baseball. He goes on, he says, if the federal government can regulate growing a half dozen cannabis plants for personal consumption, not because it is interstate commerce, but because it is inextricably bound up with interstate commerce, then Congress's Article 1 powers, Article 1, Section 8 he's talking about, as expanded by the necessary and proper clause, have no meaningful limits. And we know the founders were pretty smart dudes, and they would not have put limits into a document when they really meant the government can do whatever it pleases. There's no point in having all this debate about all this stuff. And even if you disagree with what they talked about or the plan that they had, they certainly meant for it to have limits. And they explained it that way, and it was approved by the people of the several states under that particular understanding. So those are some interesting dissents. Here's Mike Meharry. He makes a really good point whenever he covers these types of things when we're covering legalization efforts in the states. He says, of course, the federal government lacks any constitutional authority to ban or regulate cannabis within the borders of a state, despite the opinion of the politically connected lawyers on the Supreme Court. If you doubt this, ask yourself why it took a constitutional amendment to institute federal alcohol prohibition. If they could have just done it by a treaty or just passing something by Congress, then why didn't they? Why did they go through the major process of a constitutional amendment to ban alcohol? Because until the court expanded things, no one thought that they had the power to do this type of things. And here is Lawrence Vance at Future Freedom Foundation. I thought he really hammered this home. I'm only going to read this whole series of paragraphs talking about the constitutionality of the drug war in its entirety is so powerful. But here's a couple of highlights. I will link to it in the show notes, fff.org. He says this is an article called Why I Am So Passionate About Ending the Drug War. And he says the Constitution not only doesn't mention drugs, it nowhere authorizes the federal government to regulate, monitor, or restrict the consumption, medical, or recreational habits of Americans. Pretty straightforward. He says the federal government has no authority under the Constitution to prohibit or otherwise criminalize the manufacture, sale, possession, or use of any drug. The Constitution nowhere authorizes the federal government to have an Office of National Drug Control Policy, a Drug Enforcement Administration, or a Substance Abuse and Mental Health Services Administration. The Constitution nowhere authorizes the Congress to pass a Controlled Substances Act, a Comprehensive Drug Abuse Prevention and Control Act, or a Combat Methamphetamine Epidemic Act. He goes on, he says, when progressives in and out of the national government, think about this. This is the same thing that Meharry was talking about. When progressives in and out of the national government sought to prohibit the manufacture, sale, or transportation of intoxicating liquors after World War I, we're talking about in the 19-teens, I think it was ratified in 1919, somewhere around there. He said after World War I, they knew they could do so only by amending the Constitution. And here, yeah, I guess it was 1919. That is why the 18th Amendment to the Constitution was adopted in 1919, just hammering home the point that no one ever, when they were ratifying the Constitution, ever considered this as a power that was delegated to the federal government, which is why they needed an amendment to do so. And when they learned that they couldn't enforce this, when 25 states had banned funding for implementing the Volstead Act, over time it wasn't really going into effect anyways, and they went through repeal. They didn't just do it by legislative fiat. Now, of course, we've got something else that went on at the same time. The other Constitution, there are many Constitution-hating presidents, not just Nixon. There was also FDR. He signed into law the Marijuana Tax Act of 1937, which was enacted August 2nd of that year. This was a U.S. act that placed a tax on the sale of cannabis. Even at that point, I don't think they were ready. Maybe they would have done it at the time, but they didn't have all the Supreme Court opinions on their side to expand the Commerce Clause the way it's been expanded today. And even if they wanted to, in the FDR administration, completely ban it, they had to get something on the board. And we know that the power to tax is the power to destroy, so all you need to do is get your foot in the door with a small tax, and they can build it up to something far worse over the years. So the Marijuana Tax Act of 1937 placed this tax on cannabis. This act actually was overturned in 1969 in a case that I actually didn't know about until the last couple of days, Leary versus the United States. This is Timothy Leary sued. He was, I guess, arrested, and he sued, and he said, like, look, you can't do this. It was repealed by Congress the following year in 1970. But if you think about it, waiting on a Supreme Court strategy, waiting for the federal courts to overturn something, which I know a lot of people are now talking about because of Clarence Thomas saying that, well, maybe, we really should get rid of this. This doesn't look like it's necessary or proper. But when is it actually going to get to the point where he's not the only one saying that? And the court has taken a case and they've gone through all the standing issues. I mean, we could be looking at decades and decades more. We're talking about 32 years before the Marijuana Tax Act of 1937 was held to be unconstitutional by the Supreme Court. And then the following year, knocked down by Congress. So what are we looking at waiting for the feds, for the federal government to deal with this on the Controlled Substances Act? I think it's going to be wait forever. So in the meantime, it wasn't just that tax act. We had this expansion of the Commerce Clause that really, really ramped up in the New Deal era. And I covered this in an episode last summer, July 17, 2020. 4 cases that expanded the Commerce Clause. There were 3 during the New Deal, and then the more recent one was the Gonzalez versus Raich case. And check this out. This is from Congressional Research Service. They noted that the Raich case was tied directly back to one of those 3 cases during the New Deal, Wickard versus Filburn. This is how they put it. The court, in reaching its decision in Gonzalez versus Raich, specifically relied on Wickard versus Filburn in 1942, which held that Congress could aggregate the impact of individual actors on the interstate market to find a substantial impact on interstate commerce. So it was no longer that the Commerce Clause was really meant what the founders and ratifiers thought it meant, which was actual commerce. It was stuff that merely had an impact on commerce. So there are people who really want to expand that now to all human, all gainful activity. So basically anything and everything. And Thomas warned about this. Clarence Thomas warned about this in 2005. There are no meaningful limits if interstate commerce is really the growing of a product in your own backyard, in your home, never buying or selling it, never crossing state lines. And I think he was absolutely correct back then, and he's correct again today. So going back to Thomas, he says, whatever the merits of Raich when it was decided, federal policies of the past 16 years have greatly undermined its reasoning. So even though he was against it, he's a team player still, and he's recognizing that the court held an opinion on this. So he's being professional about this. There's a certain kind of decorum amongst these Supreme Court people. It's weird to me, but anyway. So he's saying whatever the merits of this, even though he opposed it right off the bat, he says once comprehensive, the federal government's current approach is a half-in, half-out regime that simultaneously tolerates and forbids local use of marijuana. And the reason he's talking about this is because the federal government isn't doing a full enforcement. And I think he makes a mistake that I'm going to get to on this in just a moment. He says this contradictory and unstable state of affairs strains basic principles of federalism and conceals traps for the unwary. He said, adding that though federal law still flatly prohibits the intrastate possession, cultivation, or distribution of marijuana, the government post-Raich has sent mixed signals on its views. And he closed out this statement with this. Again, I said it earlier, but this was the last sentence of this 5-page statement. He said, a prohibition on intrastate use or cultivation of marijuana may no longer be necessary or proper to support the federal government's piecemeal approach. And I think the only disagreements that I really have on this, I guess, first of all, I absolutely agree with his dissent in 2005 that it was never authorized. There was never a commerce power that authorized this, even if you try to expand it under necessary and proper. This was always wrong. It was never necessary. It was never proper. It was never interstate commerce. And even the CSA in and of itself shouldn't have been authorized in the first place. It should have been rejected all along. But of course, we can't rely on the largest government in the history of the world to limit its own power. Anyways, but on the other hand, he's talking about how the feds have sent mixed signals. And I don't think that the feds have merely chosen a piecemeal approach on at least marijuana out of the goodness of their hearts. They haven't just been like, well, let's just stop enforcing here and stop enforcing there. We're going to be aggressive here and not there. They've been resisted on a state, local, and individual level for decades. Case in point is Connecticut. Just on June 17th, literally the 50th anniversary of Nixon's declaration of the global war on drugs, here's Mike Meharry, Connecticut became the 18th state to legalize marijuana for adult use, despite ongoing federal cannabis prohibition when Governor Lamont signed Senate Bill 1201 into law. I think it goes into effect just starting tomorrow or on July 1st. And then another case in point, on Tuesday of this week, was, where is this one? In New Mexico, a new law went into effect just this week in New Mexico. The same thing. Under the law, Mike Meharry writes, adults 21 and over can possess up to 2 ounces of marijuana, 16 grams of cannabis concentrates, and 800 milligrams of infused edibles. The law also allows home cultivation of up to 6 plants per person for personal use, with a limit of 12 plants per household. The interesting part is, under federal law, all adults 21 and over, under 21, can possess 0 ounces of marijuana, 0 grams of concentrates, 0 milligrams of infused edibles. And under federal law, home cultivation is limited to 0 plants per person, with a limit of 0 plants per household. So this is all happening in New Mexico and 18 other states, despite the fact that the federal government at every level considers it illegal interstate or intrastate. Doesn't matter if it's handed out, grown on your own, or whatever, medical use, recreational use, or anything in between. So we now have literally 36 states that are defying Washington, D.C. on cannabis prohibition, 18 with recreational, and another 18 for medical purposes, legalizing what the federal government prohibits. In 2015, I covered this in a video, and I actually made a little bit of a prediction. I pointed out that the people in the states, they learned the right path forward. I guess it's kind of a pun on the name of this podcast, Path to Liberty. And I put it this way: even in the face of increasing federal enforcement measures, the states found the winning path. It's only a matter of time before they overwhelm federal enforcement capabilities completely, and the feds will have to act like they've decided to drop the issue just to save face. Let me pull this up on the screen. Again, even in the face of increasing federal enforcement measures, the states found the winning path to liberty. The people, the states, local jurisdictions, and the like. And I think at the end of the day, the message is pretty straightforward. When enough people say no to the federal government, and enough states or localities pass laws backing those people up, there's not much the feds can do to force their so-called laws, regulations, or mandates down our throats. Well, I hope you guys found this interesting. I hope it was educational. I hope you learned something more than anything. I really appreciate you spending some of your time with me today. If you support the show, you like this episode, you like our work at the TAC, you can do a few free, easy-peasy things to help us spread the word. All of the mainstream platforms are pretty easily triggered with their algorithm. So if you leave a review on Apple Podcasts, you hit a like button on Facebook or YouTube, or you retweet on Twitter, you leave a comment wherever, that's going to trigger that algorithm and tell the platform to show the program to more people, and it's really helping out a great deal. I can't thank you enough. Of course, if you want to put your financial faith behind our work, do not feel any pressure to do so. We're going to continue doing this, whether you're able to pitch in or not. But if you do have the means, it starts out as little as $2 a month over at 10thamendmentcenter.com/members. Again, I really appreciate you being here today. I hope you enjoyed the episode, and I'll see you next time here on the Path to Liberty.